Hello there and welcome to the Employment Law Show. So good for you to join us over the next 30 minutes. I guarantee you not many things, but I'll guarantee you this. You're going to learn a lot about your employment law rights for sure. Lior Samfiru beside me right there. Lawyer, of course, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed law firm in the country. The numbers and emails, etc. to reach out to Lior and his wonderful team anytime. I'll start with the number 1-855-821-5900, help@employmentlawyer.ca, and a website that was built a few years ago, crafted just for you. It's so simple to use, full of information and contact information as well, called pocketemploymentlawyer.ca. You'll remember maybe from the past TV shows and even our radio shows across the country, we talk about the severance pay calculator. Well, now that is not only a standalone site, it's now rolled into pocketemploymentlawyer.ca. Over 2 million people have used the calculator. They've had their eyes opened up as to what their severance really should be. It's free, it's anonymous, so go there anytime, again, through pocketemploymentlawyer.ca. And the live stream Lior does every week on YouTube and Facebook as well, at ST Lawyers, to join that conversation as well. Lior, today, how to handle abuse and harassment in the workplace. Massively important topic. We'll get to that in just a bit. Some phone calls and emails from our radio show as well, but we always start off with the week that was. What do you got cooking this week?
Well, John, I have a lot of questions answered, and I'm going to share a lot of the information that I shared with my clients, the people that call me on this show. You know, this is the show where we talk about the rights you didn't even know that you had. If you knew everything we're talking about, this show would be not as important. But you have all these rights. Our laws in Canada and our employment laws are quite good. They're very extensive. Some of the best employment law in the world. Okay, the problem is a lot of individuals, maybe most people, don't understand what those rights are. They don't understand the extent to which the law protects them. So on the show, we tell you what you need to know, how to deal with the workplace problems, what kind of help the law provides for you, and how my team and I can help ensure that the law is enforced in your favor. So this is the name of this game. If you have a workplace problem, a situation, you lost your job, you're being mistreated, we cover these topics, and I want you to leave this show when you turn off your TV and you're done watching to feel better about your rights, to feel better about your situation. That's the whole point. And of course, you can always contact me at the office. You can phone or email. We'll give you that contact information again throughout the show. So stay tuned for that. But let's talk about a situation that came across my desk over the past number of days. I spoke with an individual that found himself in a bit of an interesting dilemma. So he is 65 years old, just turned, and he says about 2 or 3 years ago, this was pre-COVID, he had told his employer that he plans on retiring at 65. That was his plan. He said, okay, that was kind of a chat that they had at that point. Nothing else was said, nothing else was done. He continued, and now he turns 65, and his employer said, okay, well, when's your last day going to be? Remember, you told me you're going to retire at 65, so, you know, is it tomorrow, is it next week? When is that last day? And this employee says, well, wait a second. Yeah, I did tell you that was my thought, but I haven't decided to do that. I don't plan on doing this right now. Maybe I'm going to decide in 6 months or in a year. Maybe I won't do it at all, but I'm not retiring now. So his employer said, well, no, we expect that resignation letter to come here, so you have to do it. That's when he called me. So he wanted to know, is he now bound to resign and retire because he made that comment 3 years ago? Absolutely not. Nonsense. You may tell your employer that that's your thought, your plan, your wish, doesn't matter. A resignation has to be clear and unequivocal. You have to tell your employer, ideally in writing, I'm done on this date, and that's it. A conversation, a kind of a wish list, that's not a resignation. So this employer cannot treat this employee as having resigned or retired. It's up to the employee to make that decision. Doesn't matter what the employee said 3 years ago, okay? And if this employer decides, well, you don't work here anymore, that's a termination, which would make it a wrongful dismissal, but it's also a human rights violation. This employee is going to be let go because of their age, which you can't do. There's no mandatory retirement. You can work as long as you want, and you're, as the employee, the only one that can decide if you've had enough, if you're done, if you're retiring or resigning. No one can tell you you have to. No one can tell you that they're going to consider you to have resigned. And making a comment offhand in a conversation is not going to be enough for you to lose your job. So yeah, I'm going to help this person get their employer off their back. But if you're ever in that situation where someone's telling you you have to resign, you should immediately be very concerned about that. You have to give me a call.
It's interesting though, because we've talked about cases and had calls on our radio show about this, Lior, where there's, an employee, maybe they're not 65, they might be just in their 60s, late 50s, even 70s, but, they're starting to struggle a bit at work. They're having trouble doing their job, and the employer notices this and starts nudging them towards the door, saying, you're not keeping up. We're going to have to get rid of you. You're not pulling your weight. How do you navigate that if you're that employee?
So, listen, an employer can expect that the employee does the job that they were hired to do. But if an employee cannot do their job because of a medical condition, whatever that is, then they need a doctor's note. And as long as the doctor's note says, hey, this person needs to be accommodated, the employer has to find a way, if it's possible, to accommodate. Maybe that means giving them a bit of a break. Maybe it means finding them a different job where they could do it better, or where their physical limitations won't be such an issue. But an employer cannot penalize someone if there's a medical issue that prevents them from doing their job. Whether that medical issue has to do with age or not, you can't be penalized for a medical condition, a physical condition, or a mental health condition that prevents you from doing your job. And if your employer does anything like that, you immediately should think that's a human rights violation. We need to talk right away in that case.
And how about that employer that kind of starts making suggestions? I still remember that classic story you told a few years ago about, the golf resort pamphlets being left on someone's desk. And, if you didn't work here anymore, if you're retired, you'd be able to play golf all day. What do you say?
Yeah. Right? Behind door number one, we have this. Yeah, no, it's exactly the case. And that, if you think about it, that could be embarrassing. That could be uncomfortable, being told 100%. That you really should retire. No one wants that. So an employer that does that nudges you, that keeps suggesting you should retire, maybe your time has come, maybe those young guys need someone else to work with, none of that is appropriate. Just those suggestions, those pushes to retire, in and of itself can be a human rights violation. Your employer should not. It's okay for your employer to say, do you have plans to retire? Because we want to know how to structure the workplace. That's okay. Sure. But if the answer is no, that's it. It's done. It's over. You can't be bugged about it. You can't be pressured into it. The law does not take kindly to an employer that does that.
Again, reaching out to Lior and the team if this is your issue or anything else with your job, 1-855-821-5900, help@employmentlawyer.ca is the email we always get. Employmentlawyer.ca, the website right there. I mentioned this before. There's a media tab. You'll find resources for our radio show across the country. You should tune into that. You'll learn so much more there as well. And we got a lot of great calls every week, have for almost 10 years on our radio shows, Lior. We like to play them back here, talk about them, dissect them a little bit. So our first call for this show is coming up right now.
I've been working for this company for about 11 years. Boss has turned around, basically he's looking to sell the place. Questioned him on my severance, and he told me that I'm only getting 8 weeks. Is that all I'm worth, 8 weeks? Closing the business down completely, and basically he's just selling the building and closing the business.
What kind of a job? What do you do?
Manufacturing.
Okay, and how old are you?
Just in my 40s.
So the question in the situation, anytime there's a sale of a business, the question is, are you going to continue working with the buyer? Okay? Right. If you're going to continue working with the buyer, then that buyer inherits your service and no severance is owed by the seller because you haven't lost your job. Okay? So remember, severance is paid if you lose your job or if something happens that makes it impossible to continue working. So if you continue working with the buyer, no severance is owed. Now, in a situation where you continue working with the buyer, of course, you want to make sure that you don't sign something that gives up your past seniority. But short of that, your severance or your seniority continues, and if at some point down the road, the new company, the buyer, lets you go, they'll have to pay you severance based on your full time. Where it's different is if as a result of the sale, you lose your job. So the company is sold and you don't have a job with the buyer. Then you're getting your full severance, which could be a lot more than 8 weeks. So for this person, to see how much severance they're owed in a situation where they don't have a job, let's go to pocketemploymentlawyer.ca. Let's use our severance calculator. Again, it's pocketemploymentlawyer.ca. You see that on the screen. We have our severance calculator tool there that's completely free, easy to use, anonymous. You can use it as well for your situation or a loved one situation. Let's see how much this person is owed. So 45 years of age in a manufacturing role for 11 years. Company says, all you get is 8 weeks severance. They got the 8 right, potentially, except it's not weeks. As you can see on the screen, it's 8 to 10 months of severance that he's owed. And you know what, John, that's probably even conservative. It could be as much as 12 months in some situation. So, somewhere around 8 to 10 to 12 months of severance. That's why it's important to go to pocketemploymentlawyer.ca. That's why it's important to understand your rights so you don't accept something and then realize you made a huge and very costly mistake. So again, you lose your job, you're about to lose your job, maybe you're just interested and curious, what would I be owed if I ever lose that job? No problem. Grab your smartphone, go to pocketemploymentlawyer.ca, use the severance calculator, and you'll know exactly what the answer is in a few seconds.
In this particular case, as we heard on the call, this person was losing their job due to the shutting down of the business. Describe the difference between a company just shutting down and closing its doors versus a bankruptcy. How does that affect severance?
So shutting down doesn't mean you don't get severance. Shutting down means the company says, you know, we're just not profitable enough. We don't want to continue running this business. Fine. They still have to pay severance. They still have assets, you know, equipment, the property, accounts receivables. So they have to pay your full severance. On the other hand, if a company is formally in bankruptcy proceedings, that means that that money that they may have is already spoken for by secured creditors, and that may mean you don't get any severance. So bankruptcy, very bad situation for an employee. The business shutting down, no, you still get your severance, but you have to act quickly. You can't sit on your rights in that situation.
You want to ask questions anytime? Well, you can listen to the radio show and call in. There's one avenue. There's also terminationquestions.com. Terminationquestions.com. Again, very simple to use. It's free. It's anonymous. You just punch your question in there. It'll get answered on the outside, but sometimes it'll appear on this show or one of our radio shows. We'll get to one here right now, Lior. Again, terminationquestions.com. I've received several negative performance reviews from my direct supervisor, but many elements included in the reviews are inaccurate. How do I address the issue without losing my job?
Excellent question, and extremely important thing to be aware of. And this is not uncommon. You get a negative performance review and you don't agree with it, or some of the facts and some of the criticisms are just not correct. Well, what do you do about it? Very simple. You say something about it. You correct them, and you do that in writing. Okay, so that there's no question about it. Now, you don't want to be aggressive. You don't want to say, you're so dumb for saying that. How dare you? No. You're going to be very professional and say, you know, employer, you said that I didn't do a good job on the project. Well, here's what you actually need to know about what happened. So you have to say so in writing, politely and professionally. By doing that, you're going to prevent the company from relying on that negative performance review if they ever want to terminate you for cause. You're going to make it much more difficult for them to terminate you for cause. You'll ensure that if you are let go, you get compensation. The worst thing that you can do is if you don't agree with the performance plan or a negative performance review, is that you don't say anything about it. You're silent. Silence is the same as acceptance. And that means your employer can then rely on it. Yeah, you accepted what we told you, so how can you complain about it now? No. Say so in writing. Email works great, and that protects your rights.
Coming up here, how to deal with abuse and harassment in the workplace. But first, we'll take a wee break. In the meantime, 1-855-821-5900. There's the number to reach out. The email is help@employmentlawyer.ca. And again, we just used it, terminationquestions.com. We'll come back with lots more employment law shows. Stick around. People think you should go to the government to get severance pay. Employmentlawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at employmentlawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. Employmentlawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. Okay, and back we are, Employment Law Show. Thank you so much. John Scholes here beside me, of course, Lior Samfiru, co-founding partner, Samfiru Tumarkin LLP. Happy to be the most positively reviewed law firm in the country. I want to reach out to Lior and a member of his team. Don't hesitate to just pick up that phone, get educated, have a chat. It'll cost you nothing to do it. 1-855-82 821-5900. Email help@employmentlawyer.ca. And if you prefer to go online, first there is a website built just for you, free and anonymous. Again, pocketemploymentlawyer.ca. Lior, our topic for the day, let's get into this, how to handle abuse and harassment at the workplace. How important has this topic become in the last couple of years for you?
It's one of the major and most common situations that I deal with every single day. You know, when I started practicing law 20 years ago, didn't talk much about that. There weren't too many people calling concern about workplace harassment. It's not that they weren't harassed or mistreated. They were not comfortable talking about it, and there was this assumption that the law can't help them. Well, people understand now that it's not acceptable to be mistreated, so I get calls all the time how to deal with it. So it's important that we address this topic, because you may, despite through no fault of your own, deal with a situation where someone's not treating you properly in the workplace, and you need to know what to do, what to say, and what the law does.
Okay, number one is this, pal. Understand that all employees are entitled to a safe and harassment-free environment. You bet.
That's a good place to start. So you have to always keep in mind that if you're being mistreated, you're being harassed or bullied, that's not okay. Okay, you have a right, and I'm not talking about some sort of a natural right. I'm talking about a legal right to be in a harassment-free work environment. You have a right to not be in a poison environment, in an abusive environment. The law says you have a right, and it's a term in everyone's employment situation, that you have a right to work in an environment that's proper, that's conducive to work, that's supportive. So if something happens that takes away that right, and now you're in an abusive relationship with your boss, with a coworker, well, now you have to understand that that's not okay. The law is going to say, no, that isn't okay, and you can do something about it. So always remember, don't feel guilty because someone else is mistreating you. They're the ones actually in breach of the law.
Number two is this: document in writing all instances of harassment and bullying. That goes in general, right, for your work life.
You always want to understand that the person that's harassing you is not going to admit it, right? They're not going to admit it to me. They're not going to admit it to a court. They're not going to admit it to the boss, right? They're not going to admit it. They're going to say, no, never happened, right? So what do you do about that? Well, you have to find a way to document that, keep a record, maybe write down what happened, maybe send someone an email at the time confirming what was just said, maybe even have a recording, because ultimately, if you're going to say someone harassed you, you're going to want to have a way to prove that, to establish that, because the harasser is not going to help you. They're not going to hang their head in shame and say, yes, I did it. So how do you prove it? Emails, documenting, recording something, maybe a witness that's willing to corroborate what you're saying. If you have that, you're going to have a lot of power to do something about it. It's ideally, you don't want it to just be your word against someone else's.
What if that email doesn't get a reply? Nothing.
So you send an email to the person that's harassing you saying, listen, I didn't appreciate today where you called me names and you told me whatever, and you don't get a reply. Perfectly fine. Remember, silence is the same as acceptance. So their silence is the same as them accepting what you've told them. You don't need a reply. You just want to have sent that email and that there's a record that it was sent.
You're allowed to record. You mentioned that as well, right? You can record?
Absolutely. As long as you're part of the conversation, you are legally allowed to record. So I could have a recorder here in my suit pocket recording a conversation that I'm having with someone. They may not like it, they may not appreciate it, but I'm allowed to do that. What I'm not allowed to do is leave a recorder on the table and record two other people speaking when I'm not part of that. That's not legal. But if you're talking to someone, legally you can record it.
What we're talking about is dealing with harassment and abuse in the workplace. Number three, Lior, report all incidences to the appropriate party or department within the workplace.
So you have a way to prove what happened. You have something to corroborate. Well, talk to the right person in your organization. HR, the finance people, the owner, whoever the right person is within your organization, let them know what happened. Tell them, okay? And do that in writing. You want to have a record that you said something. You don't want the company later on to say, we didn't know about it, you never told us. Send an email saying, here's what's happening, here's who's involved, and here's the information that you need to have, employer. By doing that, now the onus turns on the employer to do something about it. So definitely, don't be afraid. You can't be punished, by the way, for talking about it, for complaining about it. You should always feel comfortable and confident to do that.
You know, my part B always for that question is, what happens if the person you're supposed to report to is the one doing harassment? The big boss, maybe it's a small company, 3 people, right?
Yeah, so it's easy for me to say, yeah, go talk to someone. What if there isn't anyone to talk to? Well, then that's when I get involved. If you can't deal with it internally within the company, I'm going to deal with it myself, and I'm going to get their attention and make them do what they have to do. Ideally, if there is someone you can talk to, at least as a first step, do that. If you feel that there isn't anyone, there's no point. It's the big owner of the company that's harassing me. Call me and let me deal with it.
Number 4 is this: expect a workplace investigation to be conducted by the employer.
So you've told your employer about it. You let them know you're being harassed or mistreated. What does that employer have to do? Well, that employer, as a first step, have to conduct a serious and thorough investigation. They have to take it seriously, and they have to talk to you and whoever else is involved, witnesses, etc., and investigate. They can't ignore it. Okay? They can't say, "Oh, boys will be boys." I've heard that too many times. Not legal.
Yeah.
Can't do that. They have to take it seriously and investigate. In some situations, that may even mean bringing an outside investigator to investigate it, because there's people out there that specialize in that. That's all they do. And once they've investigated, they have to take all measures to rectify this. Now that we know what happened, now we need to do something about it. Maybe that means letting someone go. Maybe that means providing more treatment about better conduct in the workplace, or more training, I should say, about better conduct in the workplace. Maybe that means separating people that can't work together. They have to deal with it. They can't ignore it, and it starts with a proper investigation.
Well, our 5th and final point, Lior, about abuse and harassment in the workplace is this: speak to an employment lawyer or for options and next steps if the matter's not resolved, even if you've reported it, right?
So you've done everything I've said, steps 1, 2, 3, and 4, and nothing's happened, it hasn't improved, or your employer's ignoring it. Well, that's where I come in. Okay, my team and I will deal with it. Either we can get your employer to do what they're supposed to, or we can get you out of there with compensation, without this impacting your EI, without this impacting you with your future job prospects. Okay, we can deal with that because the law is on your side. Okay, so follow those steps 1, 2, 3, and 4 as we've outlined. And if you're still in that situation, call me right away.
Before we take a break, let's grab another phone call from one of our radio shows. Lior, listen up.
I have an employee that took some time off for medical reasons. It's probably been around 6 to 8 months. We had already filled the position with a new employee, and now I'm getting a call back from the existing employee, and they're wanting to come back. One, I can't take you back because the person that I just hired has been hired at a lower rate, but is it wrong for me to say I can bring you on at a lower rate?
Great question. Great question.
It's a great question. So that employer can't necessarily require the employee on leave to take lower pay. That employee may agree. You may say, listen, the only job I have is a job that pays less. And that employee may say, that's fine, I'll come back and we'll continue working. But if the employee doesn't accept that, that's not something an employer can do. That's a constructive dismissal. So if that employer legitimately doesn't have the old job available, they don't have to fire someone to make the job available. But if there's no other job that makes sense, there's no the old job is not there. If the employee won't accept a lower wage, they have no choice but to terminate with full severance. Okay, an employer does not have the right to just lower someone's wage, even if that person has been off work for a while. If the employer lowers the wage, even if it's for legitimate reasons, it's still a constructive dismissal, meaning full severance has to be paid in that situation.
That was a great phone call. I want to grab another one, Lior, with the remaining time, but we got to take a short break first, so we'll get into that and then come right back with another call from the radio show. How to reach Lior and his team, 1-855-821-5900 and help@employmentlawyer.ca. We'll continue. More employment law shows coming right up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. right, welcome back. Employment Law Show was just mentioned right there in that quick spot. Employmentlawyer.ca is a great website to start. That should be your launching point. And from there, you'll get the media tab and catch one of our radio shows weekly, which we've been doing for almost a decade across this country. Really informative. You should tune in for sure. And an opportunity for you to call in on most of those shows and ask some questions as well. And in that regard, phone call number 3 from our radio programs, Lior, is coming up now.
After working for an employer for 7 years in sales, mostly outdoor sales, the employer hired a new general manager, forced me to sign a contract stipulating I had to work inside 1 or 2 days a week. I had to train other employees, totally different from what I was doing for 7 years, and basically said I had to sign a contract if I wanted to keep my job.
No thanks. No thanks.
Yeah, no thanks at all. And the key to remember, okay, is that your employer cannot force you to sign a new employment agreement. Just like that your employer does not have a right to change your pay, change your job, change your hours of work. They can't make you sign an employment agreement that does those things. And anytime your employer all of a sudden comes to you and says, I want you to sign a new employment agreement, be very concerned. We talked on a previous show about all the bad things that an employment agreement can have. Be very, very concerned about that. You can't be fired for cause. Now, the one thing that your employer can do is your employer can let you go, but they have to pay full severance. Remember, your employer can let you go with severance pretty much for any reason. So they can say, if you don't sign this employment agreement, we're going to let you go. But what they will have to do, and the employer may not even realize that they have to do this, they have to pay your full severance, which could be a significant amount of money. So for this person, that call that we just played from our radio show, let's see how much severance that person is owed in a situation where they don't sign the employment agreement and they're let go because of it. So we're going to go to pocketemploymentlawyer.ca again. Okay, we're going to go to pocketemploymentlawyer.ca. We're going to click on severance calculator, and we're going to input this person's information. Let's see, once we do that, what that gives us. So let's say this person is 42 years of age. We know he's been there for 7 years in a sales role. He hasn't been offered severance. Well, if he loses his job because he didn't sign the employment agreement, you see at the screen there on the screen, he's owed about 8 months of severance. 8 months. If he's making $58,000, that's probably right around $40,000 or so that he's owed. A significant amount of money that he's legally owed. You can't lose your job just because your employer wants you to sign an agreement and you refuse to sign. In fact, it may be better not to sign, lose your job, and get your severance.
Let's get one more quick question here before we wrap, Lior, again from the live stream on Facebook and YouTube at ST Lawyers. Can your boss monitor your online activity after regular work hours? I was recently rebuked for a posting on social media, and I'm not sure why my behavior outside of the workplace is being tracked.
So it's a question, is it really tracked, or did your employer simply go on Facebook and see what you posted? If they're tracking you, they have a tracking device on your computer that sees what you do after hours, not legitimate. Your employer can't track your post-work activities. But remember, social media is very easy to find. Even if you think you have your security settings, someone can still potentially see what you've posted. And what you post after work hours can still impact your job. So if you post after hours on social media that my boss is a jerk and the company is a horrible company, well, that can absolutely be something your employer has a problem with. So don't assume that just because you do something off work, it's not going to impact your job. If you say things or do things that impact your employer, even if you do those things after work, that's a problem. And social media, yeah, believe me when I tell you it's not private, it can be held against you.
Just use a lot of caution. Basically, think twice about doing it, right?
Common sense and caution, best advice.
You bet. And we're done for another week. Thank you so much for tuning in and contributing to the show. If you want to reach out now, you can do so several ways. Phone call 1-855-821-5900. help@employmentlawyer.ca. The website, free and anonymous, built just for you with the severance pay calculator, called pocketemploymentlawyer.ca. That's another way as well. We'll catch you next time on the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.